Hey everyone, we'll get started in a moment. Let folks trickle on in. So we'll get started in 1 minute. All right. Thank you, everyone. We'll get started now. My name is Mitchell Brown. I am senior counsel at the Southern Coalition for Social Justice in Durham, North Carolina, as well as the Solve Network coordinator at SCSJ. I'm grateful to be here today. I'll be moderating this lovely panel with who I'll introduce in a moment. But just before we get started, I wanted to a few housekeeping notes for everyone. So this meeting will be recorded, and we will disseminate the recording after the briefing is completed. And if there are any questions that folks have as we're going throughout the panel, please place them in the Q&A section. We'll be monitoring the questions in that chat, and we'll try to address some of them at the end if there is time. But as a way of introduction, again, my name is Mitchell Brown. I'm senior counsel at SCSJ, and I am speaking on behalf of the Voting Rights Working Group today, which is a group of 11 national and regional litigation organizations that focus on voting rights issues throughout the country. We were founded after the Shelby County Beholder decision in 2013, which made the pre-clearance provisions of the Voting Rights Act a nullity, making it harder for voting rights advocates to hold legislators accountable for voter suppression across the country. And we'll talk about the importance of the Voting Rights Act throughout this panel, and why the Shelby County decision was such a dagger in the heart of protecting voting rights. Just to give a little context for why we are bringing this to you all's attention today is next week is the 60th anniversary of the signing of the Voting Rights Act of 1965 that was signed by President Lyndon B. Johnson. And we are holding this briefing to, raise some concerns that we have about the pulling back of voting rights protections in this country and the potential destruction of the Voting Rights Act, which has been such an important tool for voting rights advocates and voting rights litigators over the last 60 years, and really has protected a lot of minority voters across this country. And so we want to raise you all's attention to it and give a little context of the history of the Voting Rights Act, where we are now and where we hope to go in the future. And so I would like to introduce our panelists. And we have a wonderful lineup of panelists today. We have Todd Cox, who is the Associate Director Counsel for the Legal Defense Fund. We have Jacqueline De Leon, who is Senior Staff Attorney at NARF, the Native American Rights Fund. We have Tom Sines, who is President and General Counsel at MALDEF, the Mexican American Legal Defense and Education Fund. And then we have John Yang, who is the President and Executive Director of AAJC, which is the Asian Americans Advancing Justice. And so we'll start out with the first question, and Todd, we'll kick it to you first. What has been the legacy of the Voting Rights Act in past fights for voting power in your community, and what is the current state of voting rights for the communities you serve or represent?
Well, good afternoon, everyone, and thank you, Rachel, for that question. The Voting Rights Act of 1965 was not a gift from the powerful. Rather, it was the result of generations of relentless grassroots advocacy, of which LDF was a part, and a direct response to the brutality on Bloody Sunday. On March 7th, 1965, civil rights marchers in Selma were met with tear gas and billy clubs as they crossed the Edmund Pettus Bridge, and they demanded voting rights. Their courage, their resolve, and their sacrifice forced Congress to pass the Voting Rights Act just months later. VRA is one of the most transformative pieces of legislation in American history. It reshaped American democracy. It outlawed literacy tests, poll taxes, which my mother had to pay in order to vote, and grandfather clauses that were used to disenfranchise Black Americans. It created and protected Black majority districts, allowing Black voters to elect candidates of their choice across the country. It instituted preclearance for places with a history of discrimination and opened the political process to millions who had been shut out, allowing hundreds of Black legislators to serve at every level of representation in the government. However, from the beginning, the Voting Rights Act has always been pushed back upon, and there always have been attempts to try to undermine it. And indeed, for over the years, the Voting Rights Act, the crown jewel of the civil rights movement, has been repeatedly chipped away by the Supreme Court. As the Voting Rights Act approaches 60, it's a shell of its former self, a shredded shield, in other words. You mentioned Shelby County before. That case in 2013 gutted Section 5 preclearance provisions that required jurisdictions with a history of discrimination in voting to first receive approval for implementing any of those changes. That unleashed a new wave of voter suppression. Since Shelby, 31 states have passed 115 laws that made it harder for people to vote, including 44 states that were previously subject to preclearance. Racial disparities in voter participation have also expanded, growing twice as fast in places that were, again, subject to preclearance. And not only did the Supreme Court undercut the Voting Rights Act, but the law is under active attack in lower courts across the country. Courts have ruled that Black voters, for example, can't join our allies in the Latino or Asian American communities to secure voter representation or fair representation. An appeals court recently ruled that Black voters can't use the Voting Rights Act directly to fight discrimination. The same court ruled that the Voting Rights Act, Section 208, which provides voters the right to assistance to cast their ballots, whether because of disability or other inabilities to read or write, also do not have the private right of action in order to challenge those restrictions. And just last term, in a case called Louisiana versus Callais, a case that we argued in the Supreme Court, Justice Thomas, in dissent, made clear his desire to eliminate Section 2's protections entirely on equal protection grounds, ignoring the decades of discrimination the Voting Rights Act is still remedying.
Thank you, Todd. And next, we'll turn it to Tom.
Thanks, Mitch. I think it's clear that the legacy of the Voting Rights Act is extraordinary. And I say that even though the community that MALDEF represents, the Latino community, was not actually covered 60 years ago in the original Voting Rights Act. It took a reauthorization 10 years later in 1975 to extend the protections of Section 2 and other provisions of the Voting Rights Act to the Latino and other communities by incorporating discrimination against language minorities. The original act 60 years ago prohibited discrimination on the basis of race or color, quote unquote, and that would not have applied to the Latino community or other communities. It took a battle even with opposition within the Civil Rights Coalition 10 years later in 1975 to extend Section 2 and the remainder of the Voting Rights Act to the Latino community. But in that half century since, it has had an extraordinary impact in the Latino community, leading to the election of multiple members of Congress, increasing numbers each decade as the Latino community, and in particular the voting Latino community, continues to grow. But beyond that, it has led to the election through fair elections at local and state level of hundreds, if not thousands, of Latino office holders or office holders of whatever race who reflect the views of the Latino community. But you also asked about where we are today, and I think Todd explained that the Voting Rights Act is under attack. But I will also point out that we need a Voting Rights Act that addresses the context of today. 60 years ago and even 50 years ago, what we were talking about and dealing with was the near total exclusion of communities of color from power in this country. So it was about fighting for that first Black representative on a city council or a school board, or that first Latino to sit on a county board of supervisors. But today we're in a different demographic context, including among voters, where the minority communities that were covered and are covered by the Voting Rights Act are now on the cusp of, in many jurisdictions across the country, achieving real potent political power, even majority power, on certain bodies at local and state level. And what that means is that those who feel threatened by the growth of our populations are stepping up to engage in what they've always engaged in, which is to follow the patterns of the past and try to suppress and deter as many votes as they possibly can. So that's a different context from 60 and 50 years ago, where it was just about getting some representation. Now it's fighting for fair representation. And that means getting representation that exceeds a threshold in the minds of those in power to make us a real threat to their long-term ability to remain in power. So we need the John Lewis Voting Rights Advancement Act, for example, to ensure that we have a Voting Rights Act that is addressed at today's context and not solely what happened 50 and 60 years ago.
Thank you, Tom. Jacqueline, we'll turn it over to you.
Good afternoon, everyone, and thank you so much for having me today. Thanks so much for leading this discussion, Mitch. We are facing a critical turning point in American history. We've seen a resurgence of racism and hostility toward our communities. These past several weeks, Native Americans in particular have been in the crosshairs as a convenient tool for distraction, whether it be the President of the United States calling for a return to the use of racist slurs as team names, or whether it be the Department of Homeland Security tweeting a picture of Manifest Destiny without mention of the genocide that arose from that policy. Native Americans are not going to be taking these insults lying down. But what these insults indicate are a wider hostility toward the idea that one, racism still exists, and two, that we need protections of our voting rights based on race. Yet that cannot be further from the truth. At the Native American Rights Fund, for example, in partnership with many of the people on the call today, we've been using the Voting Rights Act over and over to press for and assert our voting rights in an incredibly hostile landscape. And we've been winning over and over because Section 2, in particular, remains as necessary as ever. And that's because Native Americans and voters of color remain politically powerful and are therefore dangerous to those wishing to maintain control of power without regard for the rights of every citizen of this country. In Arizona, for example, the statewide election for the state attorney general was decided by less than 300 votes. And so we know that every vote is critical. And we know that the constant shaving off of our communities is a tool that is being used over and over to keep Native Americans and voters of color from being able to assert their rights. And what we're seeing increasingly is an attack on the Voting Rights Act itself. As Todd mentioned, the tools that we used to protect our communities are under attack, whether that be challenging our standing, whether that be narrowing what can be interpreted as a violation. The courts are another actor that we're dealing with over and over again in the context of the Voting Rights Act. So we look forward to having this discussion today, and thanks so much for having us.
John, I'll turn it to you.
All right, thank you very much, and good afternoon, everyone. For me, the Voting Rights Act is what made democracy real for a large group of Americans here in the United States. Certainly, the 13th Amendment granted citizenship and established citizenship for African Americans and through birthright citizenship, oftentimes for Asian Americans. Certainly, the 14th Amendment promised equal rights or equal protection. But it wasn't until the Voting Rights Act that some of these promises, some of these dreams really came into actuality and came to be realized. From the Asian American lens, we have also had to fight for our rights, not just simply to be a citizen in the United States, but then even after becoming a citizen, fighting for our rights to be able to vote. And what that looks like is similar to the African American community, oftentimes around literacy tests, oftentimes around voter intimidation. For our community, oftentimes around property ownership through things such as alien land laws. It wasn't until the passage of the Voting Rights Act, which took place on the same year as the passage of the Immigration and Nationality Act, that we had the freedom, we, the Asian American community, had the freedom to immigrate, the freedom to become citizens and to have voting rights. So we think about this, how it has transformed for our Asian American community from a community that in 1965, when the Voting Rights Act was passed, of less than 1% in the United States to present day when we are approximately 7% of the United States. Tom mentioned this, and it's worth repeating about sort of what this means for the Asian American community when it comes to language access, and thinking about it in terms of what's called Section 203 and 208. So Section 203 establishes that we have voter protections and ensuring that ballots are translated, ensuring that we have language access for certain communities that reach certain thresholds. And for our Asian American community, part of that is a threshold based on percentage, but also a threshold based on sheer numbers, recognizing that our community, when it comes to languages, can oftentimes be quite diverse, and that it doesn't necessarily have one language that dominates the entire community, but rather languages that reach that threshold, the threshold of 10,000 under Section 203, but might not reach a 5% threshold. The other component is Section 208, which is called language assistance, making sure that you have an assister of your choice at the polling place. And this recognizes that for Asian Americans, about a third of our community is what is considered limited English proficient. In other words, English is not necessarily our natural language, but recognizing that you are not less of a citizen simply because you don't speak English, just as you are not less of a citizen because you have a disability and need help at the polls. So these are some of the components that we need to continue to be concerned about as the Voting Rights Act and the Voting Rights Advancement Act is advanced into our modern age. The recognition for our Asian American community is also this. We are oftentimes still seen as what is called the perpetual foreigner. This notion that no matter how long we have lived, whether we are born in this country, that we are not seen as a citizen, that we are not seen as an American, and our right to vote here in this country could be questioned for various reasons. That is, for us, the legacy of the Voting Rights Act and why it remains still so important to us today.
Thank you, John. And thank you, panelists, for that first question. One of the things that I've been thinking about lately is, in following up on John's point, is that the VRA really effectuated the protections of the Constitution, because at the passage of the Voting Rights Act, which Todd mentioned, the courts and legislatures were complicit in continuation of voter suppression, especially in the South. And because courts weren't upholding the Constitution, Congress, and the great work of civil rights advocates such as John Lewis and others, on Bloody Sunday, led to, the passage of the Voting Rights Act, because America was forced to reckon with why aren't Black voters in this country allowed to vote, and other voters of color allowed to vote in this country. And so we saw this complicit nature of courts and legislatures together suppressing the right to vote. And sadly, today we're starting to see that again, or we're continuing to see that, I should say, seeing that again, where legislatures are not protecting minority voters, and courts, are not upholding the right to vote. We see what's happening in Alabama, actually today, where a court is hearing arguments over whether Alabama should be placed back under preclearance because they intentionally discriminated against Black voters in the drawing of their congressional districts. We're also seeing that in Texas, where there's a mid-cycle redistricting happening right now, where elected officials are not trying to protect minority voters, but are trying to protect power. And so what we are seeing is that the VRA has really helped protect a lot of minority communities over the last 60 years, but we're starting to see a peeling back of those protections and a destruction of those protections. And so my next question for the panelists is, what's at stake now? What does the path forward look like? We see what's happening in Alabama. We see what's happening in Texas. We see, as Todd mentioned, that there are over 100 laws that have been passed since the Shelby County decision in 2013, all aimed at diminishing the right to vote for minority voters. So what's at stake now? Where do we go from here? And I'll turn it over to Tom to answer that question first.
Thanks, Mitch. What's at stake is our democracy. I think so many things that are occurring today under this administration are a threat to democracy and the rule of law, but really central to what's been going on for a number of years predating this administration is the assault on every person's right to cast an informed ballot. And we need to protect that. And the way to do that, first and foremost, is to restore preclearance, which was basically disabled through striking down the coverage formula in the Shelby County decision some 11 years ago. We need preclearance again, not just because it would prevent so many violations of voting rights from moving forward, but because it is the most efficient way to deal with the challenges that we face today, which is abuse of the voting system, like Texas mid-decade redistricting that is occurring in Austin as we speak. That kind of abuse wouldn't occur if we had a preclearance regime in place, because Texas would be required to take its maps and subject them to preclearance, pre-approval, pre-review by the Department of Justice or a district court in Washington, D.C. And that would prevent them from being able to do what they're trying to do, which is put maps in place so close to the election coming up that no one could actually challenge them under the Voting Rights Act and get away with sneaking one under the wire to change the outcome of the midterm elections coming up in 2026. If we had pre-clearance in place, that would stop. I've said it before a number of times. The right wing doesn't like it because they are champions of ADR in the form of mandated arbitration. But really, Section 5 is the most powerful ADR, alternative dispute resolution mechanism, ever enacted into federal law. It enables these jurisdictions, including the state of Texas, for example, to know whether they are violating the Voting Rights Act, whether they are violating intentionally the Voting Rights Act, discriminating against communities of color, or going backwards. It enables them to know that through a very efficient administrative process without having to be challenged and defend. And then when they lose, having to pay millions and millions of dollars to the prevailing side. Instead, they get it all covered through pre-clearance early on before anything takes effect. So they don't like it, but ADR belongs here in the voting rights arena even more than it does in the consumer or employer arena with mandated arbitration. This is not an arbitration mechanism. It is a means of ensuring that you can get a pre-check before anything's implemented, and if there's a violation, you can prevent it. That's clearly the first step on the path forward to ensuring that our democracy is preserved, particularly in the national context that I described earlier.
Thank you, Tom. And Jacqueline, I'm going to turn it to you next. But just a reminder, if folks have questions, please feel free to put them in the Q&A chat. Jacqueline, I'll turn to you.
Yeah, so I think I agree with Tom that democracy is really at stake. And it's really because we don't know if there will be a future where America has a Voting Rights Act. The Eighth Circuit has issued a radical opinion that has cut off all avenues for private plaintiffs, meaning individuals, tribes, organizations, to bring Section 2 cases under the Voting Rights Act. Section 2 is the heart of the Voting Rights Act, which means that it's the mechanism by which you sue for racial discrimination, right? So whether that's a gerrymandered map or whether that's a law that has a disproportionate impact on minority communities, the Eighth Circuit has cut off all means for private plaintiffs to bring cases under the Voting Rights Act. This is a level 10 alert. It is exactly a continuation of this gutting that all of us have been mentioning. So the court's not content just to get rid of Section 5, are now trying to get rid of Section 2. And the way that the court has done so is to say that, that there's no cause of action, and that only the Department of Justice can bring cases under the Voting Rights Act. We know what a false screen that is because, there's been, 400 plus cases brought under the Voting Rights Act. Of the 180 or so successful claims brought under the Voting Rights Act, only 15 have been brought by the Department of Justice. And we know that under this administration, the Department of Justice Voting Rights section has been absolutely gutted. What used to have over 30 attorneys now only has 2 or 3 left. So we know the Department of Justice is not going to be in the business of enforcing voting rights. Instead, it's incumbent upon the people that have been bringing cases, the people who are asserting their own rights, have been bringing cases under the Voting Rights Act. So this case is called Turtle Mountain v. Howe. It was brought by the Native American Rights Fund, the Campaign Legal Center, Brian Sells and Robbins Kaplan, to on behalf of the Turtle Mountain and Spirit Lake tribes and individual plaintiffs that have successfully asserted a voting rights claim for a racial gerrymander in North Dakota. A judge found that there was a Voting Rights Act violation, and rather than challenge the merits, only challenge the merits of that determination, they are instead attacking, the state is instead attacking our very right to bring cases at all. And if this is allowed to stand, this will be an existential threat to the Voting Rights Act. And so right now, we don't know if there will be a future where a Voting Rights Act is available to our country. And so, this is really a moment for concern and reflection on this anniversary.
Thank you, Jacqueline. John, turn to you.
Sure. And let me double click and repost everything that Tom and Jacqueline are saying. As we all know, voting rights is on very shaky ground. We are in a period where we are moving backwards in time to around 1965, before the Voting Rights Act was passed, when we should be moving forward, making sure that everyone has the right to vote. At the fundamental level, if you are a citizen, it should be easy to vote. We should not be trying to make it harder to vote. And in that context, that is why the John Lewis Voting Rights Advancement Act is so important to the work that all of us are doing and should be supported. That is being reintroduced in the Senate today, and all of us are committed to seeing that happen. The reality is we are seeing attacks against our communities. I've mentioned it before. With respect to the Asian American community, is being seen as the other, being seen as the perpetual foreigner, as being seen as someone that doesn't belong. For each of our communities, we are being othered in many different ways. And part of the manner in which that othering is happening is trying to find ways to restrict our rights to vote. This is coming at the same time, as we all know, when all of our communities are getting more power, are getting more engaged in our civil society, and want to be involved in how our governments run to make sure that they serve our people. So this notion that at the same time that all of our communities are growing, are more engaged in society, that they are trying to take away our rights to be engaged as society, is very, very troubling. So at the end of the day, part of what the Voting Rights Advancement Act does is try to restore some of these protections that we have been talking about, restore some of the pre-clearance formulas, modernizing those pre-clearance formulas, as Tom said, recognizing that what we are seeing today is also different than what we saw in 1965 and part of the reauthorizations, whether it's 1975, 1992, or 2006. Recognizing that discrimination does look different today than it did in 1965, while recognizing that discrimination does still exist. At the end of the day, we want to also honor the work of people like John Lewis, people like Fannie Lou Hamer, Martin Luther King, and Wade Henderson, who championed both the passage of the initial Voting Rights Act as well as the reauthorizations that have took place over time to modernize the act, recognizing again that history is not static. How we need to protect our people continues to evolve, and that's what we're seeking to do with the John R. Lewis Voting Rights Advancement Act. Continue to evolve the Voting Rights Act to meet the needs of today. Again, for the Asian American community, part of this is about language access. Part of this is making sure that we are able to have the assistance that we need, even though we are newer immigrants and sometimes have those language difficulties. As such, we call on Congress to do its job and pass this legislation now. We also urge everyone here to continue raising your voices, to talk to your representatives, to mobilize your communities, and to ensure that no voter is left behind.
Thank you, John. Todd?
All right, thanks, Mitch. And I'm just going to repeat everything everyone else said. I'm going to co-sign. Democracy is at stake. And, I'll pick up on what John alluded to. We wouldn't be under such a threat if we weren't doing so well in making sure our communities were engaged, they were turning out, and that their rights were protected. This is a cyclical part of history that when we see some success in advancing rights, there's always backlash. I'm not minimizing the backlash. I'm merely saying we're part of a backlash that is something that always comes up whenever we start really advancing rights and we become a threat to those in power. So I want to flag that and name that because it's critically important. I also be remiss if I didn't repeat what else was said, that we are encountering all of these challenges in the context of what is happening via this administration, which is conducting a vicious assault on our civil and human rights, a vicious assault on the rule of law, really pushing the envelope. And I'm saying this because it involves voting directly. This attack includes issuing an executive order that would have required what is called documentary proof of citizenship in order to register to vote. May sound somewhat reasonable. Doesn't sound reasonable to me at all because I don't have my birth certificate handy. But they're trying to go to a shopping center to conduct a voter registration drive, which is within your rights to do. It will inevitably eliminate that opportunity by requiring those kinds of documents to be issued. Well, a court found that in violation of the law, and that EO was struck down. This is a similar EO to a law that was pending in Congress to try to do the very same thing, called the SAVE Act. So these challenges are erupting in the very moment when we're seeing success in our communities in advancing our rights, in advancing opportunities to elect candidates of choice, and advancing opportunities to have people fully engage in our democracy. Even amidst those attacks, however, there's glimmers of hope. As John alluded to and others have alluded to, there's the John Lewis Voting Rights Advancement Act that's being reintroduced today, and we are in full support of that. But there's also legal action happening that proves that fair maps in redistricting, for example, is still required. A shame that I need to reiterate that, but it is still required to have fair redistricting. I mean, Allen versus Milligan, the Supreme Court upheld decades of precedent under Section 2 of the Voting Rights Act and recognized that the attacks on voting rights of Black voters continue today. That case led to a second majority Black district in Alabama, which afforded Black people in Alabama an additional opportunity or an equal opportunity to elect candidate of choice. That case went to the Supreme Court, as I said before, was held to be validated, that ruling below was validated, and went back to trial. And the court not only reiterated its opinion that the second district was required, but found that Alabama, in choosing not to create that second district, intentionally discriminated against African American voters in that state, given its history of discrimination over the decades. We also can't rely only on the courts, and we can't rely only on Washington, D.C. I think that it's important to look to the states and what the states are doing. We are very supportive of state voting rights acts, which are in some ways replicating what is happening with happened with the Voting Rights Act, but at the state level. We've seen 8 states enact state level Voting Rights Act, which hope to eliminate opportunities to discriminate against voters, to increase opportunities for voters to engage in the political process, and to stop vote dilution. We also are making sure that voters understand their rights before elections throughout the year, not just in time for the election, but throughout the year, and are empowered to participate in the electoral process effectively, and making sure that on election day and leading up to elections, folks can cast a ballot. At the end of the day, I'm actually hopeful. I know I stand on the shoulders of folks, and we mentioned some of their names here, who fought and died in some cases for the opportunity that I can only imagine they could never imagine me having, to be able to advance and push forward civil rights and voting rights for folks. So I think that we're living in a moment where, yes, we're under threat, but I'm very confident that well-meaning folks will band together and make sure that we do not lose the rights that were so hard fought for, and that we actually advance opportunities for people to participate in the political process.
Thank you, Todd, for that. And just a reminder for the media in the room, please feel free to throw your questions in the chat. I have one last question for the panelists, and then we'll see if there's any questions from media. But one of the things that you all have talked about is the John Lewis Voting Rights Advancement Act, and how important it is that Congress passes something like that. Is the passage of the John Lewis Act, is that the cure-all for all of the voting rights ills that we have in our society? Or are there other things that we need? If we had a perfect world, are there other things that we would be able to advocate for and have that would protect voting rights? So I guess my question is, in a perfect world, what do we need? Like, what do we need to protect voting rights? And I'll open it up to anybody.
So I'll start, Mitch. I think the John Lewis Voting Rights Advancement Act is a critical step. As I said, it's a primary step, but it will not solve all of the ills that afflict our democracy. As we've all noted, there are ongoing threats to our democracy and the rule of law every day with this administration, and many of them are centered on voting rights, but others are not. They're centered on making people feel intimidated, making institutions feel intimidated. They're based on engaging in activity like racial profiling, leading to indiscriminate arrests by folks who are masked and in unmarked cars and not wearing uniforms. I certainly, as a resident of Los Angeles, see that here in my community, and it's actually happening across the country. So it's not going to solve everything, but it is an important, critical first step. I would note that in the realm of voting itself, we also need to really make proactive steps at both federal level and state level to facilitate involvement. Right? The Voting Rights Act is very good and has been very successful at preventing and stopping depredations of critical constitutional rights, like the right to register to vote, the right to cast a ballot, the right to cast an informed ballot, meaning that you can have that ballot interpreted by an assister of your choice. And I want to just pause here to note that what Jacqueline has talked about has been made worse as of yesterday. The Eighth Circuit issued a decision yesterday in a MALDEF case about Section 208, section that John mentioned, about election assistance. And in that case, Eighth Circuit, having already rejected a private right of action in a case well over a year ago, and rejected Section 1983 as a vehicle in the Turtle Mountain case, though that's still pending appeal. Yesterday, a panel of the Eighth Circuit decided that you also cannot bring a supremacy clause preemption claim under Section 208 to prevent a law that clearly violates Section 208 from going forward. So that last potential option for private enforcement of Section 208, because it would have only applied to 208, not Section 2, preemption or supremacy was taken away by the Eighth Circuit as well. This is a rogue circuit, and it's got to be stopped. But going back to what I said, we need to ensure that states and the federal government, to the extent it can within its power, take steps to facilitate participation. We need to allow people to register up to the date of the election. We need to allow people to cast remote ballots regardless of their circumstances in this modern day and age. We need to allow people to cast early ballots. All of this is being prevented, and we can stop some of that prevention, but we can't mandate through the John Lewis Act that every state implement the most effective mechanisms to allow participation at a high level for everyone. And that's what we have to do. We have to not only move beyond the John Lewis Act, but make sure that we are pushing every facilitation of casting a ballot possible in the states and at the federal level.
Since our other panelists, the world's our oyster. What is our dream?
Well, of course, the John Lewis Voting Rights Advancement Act is critically important. And, as we say, we have to shore up the shield that has been torn apart these last few years. But of course, we have a job to proactively promote and create voting rights opportunities. And we've heard a lot today about how, we are in a new era of voter suppression. And that's true. But in Native American communities, unfortunately, we still see sort of the same 1960s era discrimination that existed long ago. For a Native American living on a reservation, they may have to travel upwards of 100 miles to reach a registration opportunity. On reservation, voting opportunities are scant. They are not mandated. We need the Native American Voting Rights Act, which has also been introduced into Congress, to mandate on-reservation registration and voting opportunities. The truth is that Native Americans face continual discrimination, especially in border towns where racial hostilities can be incredibly high. Those are often where the county seats are, where Native Americans are forced to travel long distances to get their voter services. And so we are still facing sort of ground zero, very obvious discrimination. And, I think that there are actors out there that are trying to actively make it harder for people to be able to vote. So as Todd mentioned, the SAVE Act, right? Sounds reasonable, proof of citizenship. But what they don't mention is within that law, they would require you to show that identification in person at a registration site that, again, for Native Americans can be over 100 miles away. They'll also limit the types of identification that can be used to cut out certain groups. And so what we see is the ability to both cut out minority voters, make it substantially more difficult for them to comply with arbitrary rules designed for that very purpose. And so, we're still a long way. We need the shield of the Voting Rights Act to be fully functional, and we need an American populace that is very intent in the belief and in the action that every American citizen deserves the full and fair opportunity to vote.
Thank you, Jeff. Todd, John, anything you want to add? Nope.
I would only add that, I guess a couple of things. I really hope, my dream would be that, and I think Tom actually alluded to it, that we continue to look at these as our progress, but also the attacks holistically. Those who want to chip away at our democracy don't do it in a micro siloed way. They don't say, today I'm going to do voting rights. Tomorrow I'm going to do policing. They want to come after it all. And I would hope that all of us respond accordingly. We see the through lines between an attack on redistricting, the attacks on race-conscious remedies in education, the attacks on or not allowing immunity or qualified immunity to be applied in a policing situation. That we see this holistically and understand that this is really an attack on democracy as a whole, and we respond accordingly. And what does that mean? That means we look at all the communities represented on on this call as canaries in the mine. That when any one of our community members fall ill in our democracy, whether that's in the voting context or in the policing context or in the context of housing discrimination or any other context, the nation as a whole might get sick. The example I always come back to is the 2000 presidential election. There, for the first time, many progressives experienced voter intimidation, or what they considered to be voter intimidation. They experienced what they think was voter suppression. African Americans in Florida have been confronting that for decades. And again, if you look at what's happening to our community members, most vulnerable in our community as a canary in the mine kind of scenario, one understands that that is going to happen to everyone. And my hope is that we all understand that to be the case and that we all respond accordingly. When I say we all, I mean the entire country. Finally, I'll say that the kind of collective power you see represented on this phone, again, phone call, this webinar is powerful. That we think collectively across race, across ethnicity about the kinds of opportunities that exist, but also the kinds of attacks that we're suffering. And I think that particularly resources, efforts, support needs to flow in a way that represents and understands that we collectively are powerful and that we separately are vulnerable. And I think the kinds of work that the Voting Rights Working Group does, the kind of work that MALDEF, NARF, AAJC, LDF do on behalf of our communities, we often do that as a collective, as a coalition. And I think that's a really important approach that should be respected. And I think it's an approach that could be a model for others to pursue as we try to defend our democracy.
Thank you, Todd. And we have one question from our audience. What is your response to those who claim that all of these attacks on the Voting Rights Act are really just an effort to shore up election security / election integrity and making sure that only citizens are voting and combating election fraud, et cetera? So what are folks' response to that this is about election integrity and making sure that only those who are eligible to vote are able to vote?
Well, what I would say, let me hop right in, sorry, is that there's no evidence that any of this is necessary to provide further integrity to our election. And in fact, the SAVE Act, when folks were challenged, those who introduced it, to say what problem you're exactly solving for, they couldn't come up with an answer. So what that indicates to me is that you're doing something else. You're trying to figure out ways to exclude folks from the ballot box. The other thing I'll say is that we as a community understand the law, understand our rights, and we ensure that when we register people to vote or we support folks who are registering to vote, we do it in a lawful manner. It's not as if there aren't already tools in the tool shed for prosecutors to go after folks who they feel have violated the law. They do it regularly. There's no need for this kind of broad SWAT team approach to so-called voter integrity without evidence. And under the law, when you pass a law without there really being evidence to support it, one has to wonder what the real intent is. When we know, and we have evidence showing that the result of the passage of the law will do harm to our communities. So I throw the question back and say, when there's no evidence requiring voter integrity, so-called voter integrity laws, and we know those laws will cause harm because we have actual evidence, what is one left to ponder and to wonder about the intent behind proposing and passing such laws?
So I would second Todd in saying we have to call bullshit on this. There's nothing to support any idea of widespread non-citizen voting. There's not a shred of evidence. When the last Trump administration tried to set up a sweetheart body of right-wing voting folks on a commission. They had to quietly, a couple of months later, shut it down because there's simply nothing to support the allegation emanating from Donald Trump way back in 2016 that there's widespread non-citizen voting, nothing to support it whatsoever. When they do investigations and they find an isolated non-citizen voted, generally speaking, the explanation is innocent. They simply did not understand that they were not yet eligible to cast a ballot. In many cases, they were naturalized but had not yet been sworn in. So really the notion that somehow non-citizens are conspiring to undermine our elections is a narrative that is designed to demonize, not to solve any sort of problem. And we have to call it out for what it is, which is an attempt to divide us and to demonize many among us, including many, many US citizens who have every right to cast a ballot.
I wholeheartedly agree. And I also just want to say, you know, the idea of election security or election integrity, of course, those are all values that we also espouse, right? We also believe. But the way that these laws are crafted are designed to cut people out, right? So that they are designed in order to just have the type of ideas of the voters that they want to cherry pick can vote, and to make it so that minority communities can't cast a ballot. A perfect example is in North Dakota. At that time, after Native Americans flexed their political power, the very next legislative session, they passed a law that required IDs, but then also required an address on those IDs when they knew that there were homes in North Dakota, Native American homes that did not have addresses on them. That is a modern day literacy test. That is a test designed to make it so that eligible voters are unable to comply because they didn't want them participating in the American system. And I think that we need to call that out, as Tom says, right? That it's not the idea that we don't believe in election integrity or security, is that we don't believe in rigging the rules for determining that election security in a way that it will cut out eligible American citizens on the basis of their race.
I think the last thing I would mention is simply that if you poll the American public, they don't see election security by and large as an issue. If anything, they see an issue that it should be easier to vote for citizens to vote. The access to the ballot should be easier. It is not the case that the American populace is saying that it should somehow be harder or that we have concerns about fraud. That notion is perpetuated by one group of people, and that group of people is creating that echo chamber that then they cite themselves to suggest that this is the reason that they're addressing it. And to Tom's point, this is what we need to call out, is if you look at the empirical evidence, it is clear that election security is not a problem. It is also clear that the empirical evidence shows that when they have introduced measures such as voter purges, such as voter ID laws, that has reduced the number of eligible people and put barriers in their way of ability to vote.
Thanks, y'all. And we have one other question from the audience. What is your response to those who say the current administration will never relinquish power, and we've already lost control of our democratic institutions, including the electoral process?
I would have to say, first of all, I have every expectation that this administration will relinquish power in 2029 as scheduled. And that is because I have so much respect for the democratic institutions that we have in place. They are institutions. Yes, we face these problems that all of us have described of assaults on the right to vote, attempts to deter participation, attempts to prevent the casting of an informed ballot by too many citizens in our country. But in the end, our institutions, I believe, are strong enough. And if we continue to put out this rumor that Donald Trump won't give up power, whatever his intentions are, I think we're only empowering him to do more damage. The fact is, our institutions are stronger than that. And I have every expectation that this administration will relinquish power as expected under our Constitution on January 20th, 2029.
I agree. And I guess I just go back to what I had said before. I'm the grandchild of folks who fled an authoritarian regime in the Deep South. We're now seeing that kind of authoritarian regime at scale, right? When they were fleeing it, they were sharecroppers. There were voter suppression tactics, economic disenfranchisement, and we're seeing the same thing at scale now. And the way that was combated was through the rule of law, among other methods. And that's what we're here talking about today. The various tools we have in the tool shed, including the rule of law, including norms, many of which are being pushed to the extremes by this administration. We are utilizing those to push back. And I think about the attacks that are being waged against our communities through these executive orders. Many of them have gone by the wayside. We filed 6 lawsuits. I think the percentage of wins are something like 70%. Don't call me on that, but I think we're by and large, the norms and the rule of law are prevailing in this administration. So I'm as confident as John that we can use our institutions, use the rule of law, use the tools we have to push back on whatever is coming at us, including any attempts to further undermine our democracy.
So I also have optimism that there will be that our institutions will hold. I do think that we need an educated and strong populace that is ensuring that those institutions are not producing, are not propped up to create a illegitimate result. And by that I mean every American citizen has the right to cast their ballot, and they have the right to have their voices heard. If we allow minority communities to be cut out of that process, right? If we make it so that it is, for practical purposes, impossible to cast your ballot, whether that means you have to travel over 100 miles to get your registration in, if we purge eligible voters from the voter rolls so that when they go to vote, they're cut off from the ballot box through no fault of their own, and there isn't a mechanism for them to be able to sign to vote that day. If there are eligible citizens that are kept from the democratic process, then we are forcing an illegitimate result through the sheen of respectability of our democratic institutions. And what we have to do is ensure that those democratic institutions hold both in form and substance. And so that, and the way that we do that is, through the passage of the John Lewis Voting Rights Advancement Act, through the passage of the Native American Voting Rights Act, but also through the accountability of the press and the people that every eligible American citizen has the right to vote. And if that right is being restricted, that the Voting Rights Act is there to defend them.
Yeah. One thing that Jacqueline just said is something I would want to emphasize. This is why press conferences, press briefings like this is so important, to allow all of you that are reporting on these to get the facts right and to continue to tell the story of what is actually happening. Because that is when people are not informed and not informed of the actual facts, that is where we're going to see our institutions continue to erode. It's going to be a bumpy ride at times, but I remain very optimistic, as does my fellow panelists, that as long as we continue to speak the truth, as long as all of our different institutions, including the press, hold those in power accountable and inform those that are watching about what those facts are, then then we will have institutions that will prevail in a democratic norm.
Thank you for that. And I'm seeing no more questions in the chat. I just want to turn it over to our panelists to see if you all have any final words as we come up on the 60th anniversary of the signing of the VRA, the 50th anniversary of Section 203. Do y'all have any final words that you want people to take away from your statements today? And if not, that's okay too. All right.
Well, I could just say, thank you so much. And thank you so much to the press on this call for doing the hard work of educating the American people on the absolute critical moment that we are in, the pressing dangers that are facing our democratic institutions, and also for all my co-panelists that I know have been in this fight with us, and we so appreciate all of you for that. So thanks so much for having us.
All right, thanks.
And I will just end by saying, I think we have to see this commemoration of both the 60th anniversary of the original Voting Rights Act and the 50th anniversary of the extension to language minorities, including Section 203, as not just a commemoration, but as this webinar indicates, as an opportunity for reaffirmation and progression forward by ensuring that the Voting Rights Act is adapted to the current national context. And that's not just threats that we face, including that raised by the most recent question, but also the changed demographics where there is a perceived threat to the powers that be by the communities that are represented on this webinar. And we have to ensure that our democracy survives that demographic transition. If we fail to survive that democratic transition, then this experiment, this democracy, this democratic experiment was a failure. Because democracies, the best democracies, the thriving democracies are those that are able to adapt to changes in the population. And this is perhaps the most important change in our nation's history. And we have to demonstrate collectively from all communities that we will put in place the tools to ensure that our democracy can survive and thrive as it matures and grows.
All right. So I'll take a bit of moderator privilege and say thank you to our panelists, and thank you to those in the audience for coming today. I just want to end, again, taking moderator privilege with this thought from myself is, well, what we're seeing today, history shows that we've seen it before. And we have to look back at history about how to combat what we're seeing today. That's why voting rights protections such as the VRA were passed. And we, as we heard today from our panelists, we must shore up the shields of voter protection, such as the Federal Voting Rights Act and state voting rights acts. Because having the right to vote means nothing if voters aren't able to actually access the ballot box, able to cast their ballot and vote if their votes count less than others simply based on what district they live in. Frederick Douglass stated that power concedes nothing without a demand, and voters must demand fairness and equity in voting rights. And this country must rise to the occasion to protect voting rights and to truly ensure that we live up to the democratic ideals that Tom mentioned in his comments. And I'll leave you with this quote from Hamilton: history truly has its eyes on us. And so thank you for everybody joining us today, and have a great day.